Trial lawyer Mark Nebrig of Moore and Van Allen in Charlotte, North Carolina, manages complex business litigation. Mark will focus today on the impact of the Garlock asbestos bankruptcy decision on the 6,000 companies, ranging from CBS to IBM to Xerox and Viacom, that are asbestos defendants today. He'll discuss the asbestos bankruptcy trust system, in which companies check in, drop off their asbestos liability along with payment, and check out asbestos liability free. To date, more than $30 billion have been deposited. You think they have an ATM? Your company could be one of the 6,000 that are at risk. Please welcome Mark Nebrig.
Well, good morning. I am here to talk about a case that might have rippling effects for folks in this room and their clients and their future clients. But at the very least, it is, I think, fodder and a good success story for the defense bar that hopefully you'll see at the end of this, that is good fodder for cocktail parties or for wine country barbecue events or things you might be attending to later, because it is in re Garlock. It is an asbestos bankruptcy case, and I'm not going to talk about asbestos science on this. I'm not going to talk about the funhouse that is the bankruptcy code, but I'm not a bankruptcy attorney. I'm not an asbestos attorney. I'm primarily a securities attorney, and I've seen firsthand, I think, the overzealousness, let's just say, of plaintiffs' bars out there in some of these class actions or mass tort situations where they are taking advantage of a system and knowledge that they have that they're not imparting to the defendants in these cases and in the targets that they kind of go from one company to the next to the next. And because of that, again, I think the impact of the Garlock bankruptcy in exposing some of that, the overzealous tactics, let's just say, of the plaintiffs' bar and the asbestos claimants world may have, again, those rippling effects that are part of what we do on a daily basis with our clients that are exposed to some of these mass tort strategies and situations that Garlock was faced with. Now, asbestos is not going anywhere. You see the late night television, maybe even the middle of the day television. I don't watch TV in the middle of the day, but the fact of the matter is that even though it's a 50-year-old industry, it's still got another 30 or 40 years of legs left in it. And because of that, and because most of the primary offenders of asbestos making, the insulation companies and the like, have declared bankruptcy and have left the tort system, today there are still 6,000 asbestos defendants in the tort system today, with 200 of those being primary targets of the asbestos claimants bar that is well-funded, as we all know. And they're not all predictable because of the conglomerates out here, because of merger and acquisition activity and the types of integrations that we're seeing in our economy. There are many of our clients that are buying asbestos litigation. Most of it is known, some of it may be not as disclosed in the reps and warranties out there. And so you can see just a sampling of some of the asbestos defendants that are out there today. They are not the usual suspects because they're not in the tort system. So we have the Xeroxes or the Saks Fifth Avenue. I guess Miguel would be interested in that one. But then, IBM or Exxon, but, or even, Anheuser-Busch, to my personal dismay, is part of this list of these defendants out there. And so if you sit here and you're thinking about this may not affect me or may not affect me now, it may in the future, and you may have to provide some advice and counsel with regard to being a defendant in this system that's been around for a long time. And Judge Hodges, which is our judge who provided this Garlock opinion at the end of the day, provided a scathing opinion that is now being used by asbestos defendants across the country to try to expose some of the things that we did and we exposed with regard to the asbestos claimants bar to try to limit their liability and limit their payments that are being made in this asbestos system. Now, just a brief primer on the asbestos system itself. Now, it's been around for a long, long time, as we all know, and we all think of the insulation companies and some of the primary asbestos products makers that were in the news even in the 70s, 80s, 90s, and in the 2000s. And with those hundreds of thousands of individual claims against them, that crush of those payments and that liability forced those companies into bankruptcy in the 90s and into the 2000s. And this was the system into bankruptcy. They would take that company, go into bankruptcy, and they would determine whether by settlement with the asbestos claimants bar or by the court order, how much is going to be enough to fund the current and the future claimants' liability payments for that company to be made. And they'll come up with that number and establish an asbestos bankruptcy trust, which that company would then fund and then leave it there for all time and exit back out of bankruptcy into the corporate system and leave their asbestos behind. That's why you have a lot of these insulation makers who declared bankruptcy, funded by the billions of dollars, left and are now multi-billion-dollar, very successful companies, asbestos litigation free. And so that was the system. And once that system began to really take a kind of a wave effect in those early 2000s, those primary and even secondary asbestos products manufacturers were exiting the tort system and going into the bankruptcy system. And what that happened with those what they call the big dusties. Again, these are terms that everybody knows apparently except me when I learned this when I was doing this case. But these big dusties and all these primary defendants that left the tort system funded, and they in the bankruptcy trust system have $30 billion funded in those trusts to pay claimants, both current claimants and future claimants for the next few decades, for their damage, for their relief, for their, again, what they would call the pain and suffering. What has happened, however, is that these trusts are being administered by and being gate-kept by the asbestos claimants bar. So not only do they set them up coming in, but any money coming out is controlled, and the access to the information is controlled by the asbestos claimants board. So there's a fox in a hen house situation as far as that's concerned. And so when you are thinking about a tort defendant like Garlock Sealing Technologies, which is a gasket maker, it is not a dangerous product manufacturer. It is a very small and always had been a very small defendant when there were 30 or 40 or 50 defendants named on the caption for these individual plaintiffs in the tort system. Garlock figured, hey, they're all leaving, all the money's going to the trust bankruptcy system. That's where the plaintiffs will go to get paid and be compensated for their sickness and disease. We will be left alone and be able to go on with business as usual. That didn't happen. What happened was Garlock became a primary defendant in the tort system. What Garlock became was the only defendant in some litigations, some individual claimants' cases, where Garlock was named as the sole product that they were exposed to and that no other product or company was named. And because of that, becoming a primary target in the last 5 or 6 years of its pre-bankruptcy existence, Garlock was forced, like the others, to file bankruptcy to try to set up a trust and get out from under the yoke of asbestos. Again, the purpose of this was to establish that trust. And really the measure of, or the standard is, what is the future liability to claimants in order to establish that fund and channel all of those future claims into that trust system in the bankruptcy where those will be handled and Garlock could emerge outside of the bankruptcy system and move on with business. What Judge Hodges had to decide was how much. What's that number going to be? You got to estimate that liability for current and future claimants. And as you can imagine, there was a bit of a disagreement between us and the asbestos claimants bar. And the measure of that disagreement was about $1 billion. So we said, hey, look, even though we don't think we're liable, we know that there's going to be pressure on us in the tort system. We'll go into bankruptcy. We will fund. We think the number should be $125 million for compensation for what we could possibly be determined to be liable for you guys. The asbestos claimants bar and those folks that were on the other side of this estimation trial that I was a part of said, no, it should be $1.3 billion. And for a company like Garlock, $1.3 billion does not allow you to emerge from bankruptcy. And so it is a seizing of the full control of the company. So that's why we had to fight it, and that's exactly what we did. Why is that such a huge discrepancy? Well, the asbestos claimants bar has been doing this for 30 or 40 years, and so they have, just through sheer volume and repetition, they've established a standard methodology for asbestos estimation that says hey, this is the way it's always been done. This is how we do it. We just take the last 5 years or so of the settlement history of these bankrupts, and we'll just do the math and extrapolate out over 30 years, and whatever the number is the number. That's the way we've always done it. That's the way these 30 or 40 other bankruptcies occurred, and that, I mean, as far as that particular type of math, and we should just do that here. Whereas we on the Garlock side said, no, this is about liability, and liability is not about settlements. And you should come up with a method that actually bases the legal liability in the tort system. And so we developed basically a three-legged strategy to bolster our method, but also to discredit the method of the asbestos claimants and the standard methodology. The first one is a simple, and it'll be brief, but we said we didn't make anybody sick. As we all know, you've got sympathetic claimants on the plaintiffs on the other side. You have to get a little sympathy for your corporate defendant on our side. And at the end of the day, Garlock as a gasket maker in the same environments as all the insulation companies' products and the like really didn't cause anybody to be sick. And we had a Sixth Circuit holding in one case that was really kind of something we banged the gavel on a lot, which was that the judge said that, gaskets cause disease is like saying one who pours a bucket of water into the ocean has substantially contributed to the ocean's volume. That's a nice thing to have and to wave around for a judge if you're trying to say, hey, look, we're not that liable. We're definitely not liable for $1.3 billion. The second piece that we use, which is that legal liability determines the trust funding, not settlement history. In other words, settlement, as we all know, is not admission of liability. That's what we all have in our settlement agreements. Simply because we're settling doesn't mean we are liable. So using that as a measure of liability is absolutely the wrong way to go. And just a shout out to Dr. Bakes, who was incredible to come up with our $125 million number using actual tort system experience by Garlock and others in the system, and taking that out into the future to come up with $125 million. The third leg of this was really what was the fun thing to do, which is that you can't base it on settlement history for Garlock because the settlement history is infected with intentional disclosure, lack of disclosure and concealment by the asbestos plaintiffs and their lawyers in the tort system when we were having to settle these cases 5 years before bankruptcy. We sat there and said, hey, look, there's $30 billion. Why are we the primary defendants, and why are our costs and settlement costs and trial verdicts, why are they going through the roof once all these folks exit the tort system, and the plaintiffs should be going to that bankruptcy system to get payment for their injuries? We had a situation where in the discovery itself, these are the individual claims, the individual plaintiff tort cases that we had, Garlock was being named only by itself, and there were no other exposures that were being identified by these plaintiffs. When you have a bankruptcy and tort system that are not talking to each other over the same types of cases, it causes an opportunity for the asbestos claimants to get paid twice, 3, 4, 5, 6, 7, 8 times over. And so that's what we were identifying, and what we also suspected, because our costs were going up so high 5 years before bankruptcy, is that the plaintiffs were hiding their exposure. When everybody was in the tort system, all the plaintiffs were saying, yeah, they were making me sick, pointing to the insulation companies. Once they left the tort system, the plaintiffs individually were saying, I don't remember anybody but Garlock. And Garlock is a gasket. It's in a flange that's surrounded by insulation, that's surrounded in an environment of all types of asbestos insulation. And these plaintiffs were saying, I only remember Garlock. That's the only company, that's the only product that I was exposed to. Now, with that exiting of all of these, let's just say, kind of primary defendants from the tort system, they also exited from the discovery in our individual cases pre-bankruptcy. They were no longer identified, and the average settlement goes up for Garlock many, many-fold. Paying a little bit when everybody's in the system, everybody leaves, all of a sudden Garlock's costs go up. And of course, their standard method is to take the last 5 years and take it out for the next 30, extrapolating it to $1.3 billion. That is what we said. We need discovery, Judge Hodges, to figure out why that is. And this is where we found out in that discovery, after all the efforts of our adversaries to hide that and to keep us from that discovery in this bankruptcy, what Judge Hodges allowed us to do is limited discovery for certain number of these individual plaintiffs that we had litigated against. And what we found was astonishing. We went to the trust. They had to give us the information on these individual plaintiffs. And at the exact same moment as these individuals are litigating against us and saying, only Garlock, there's no other exposure that we have, we only know your product and nobody else's. At the same time they're saying that in our litigation, on average, those plaintiffs were making 19 different claims against bankruptcy trusts saying that those products made them sick and you ought to pay me out of your bankruptcy trust. Luckily, we got the discovery. Luckily, Judge Hodges saw it, and what that happened then, he said, well, I am not going to trust the settlement history. We're going to go to $125 million. Good win for us. And in so doing, he comes up with an opinion, Judge Hodges, that is now being used across the country for defense and for access to that trust information, because he peppered his opinion, which is part of the materials, with some scathing opinions, so to speak, of the conduct of the asbestos claimants bar during that time, about the disappearing of the exposure evidence, about each and every one of them contains demonstrable misrepresentations, and most importantly, the last bullet, which is it appears certain that more extensive discovery would show more extensive abuse, which again, if you are currently in the system, in the tort system, you take that and say, look, this is what has happened, this is what has been uncovered. Judge, order these plaintiffs to give us their trust information, order these trusts to provide this information, then suddenly either a couple things happen. One, you find out enough to make your liability go to almost nothing, or number two, the plaintiff dismisses his case and the lawyer runs away because he doesn't want you being a part of the discovery process. At the end of the day, even in the opinion, Judge has a concealment chart where he says, in these cases, they disclosed some, but they didn't disclose 25, 22, 23 different trust claims they were making at the exact same time they were suing Garlock as the sole injurer of an asbestos manufacturer that they had cited. At the end of the day, the settlement approach was not the right approach because of the infection of the concealment and the misrepresentation, which again gives a whole lot of credence if you are negotiating settlements to say that's not at all what we're going to go. We're not going to do that because settling at that amount now, you're going to bite me with that in the future if things happen to hit rough patch and we go into bankruptcy. So what? Is it a game changer? Is just a guy in North Carolina, this judge that just got it wrong, and so everyone should ignore that and not look behind the curtain? Of course not. We are now seeing more and more current asbestos defendants, and again, there are 6,000 of them out there, that are taking Judge Hodges' opinion and saying to their judges in their tort cases, look, we need this information. Order these plaintiffs to do so. Order these trusts to give us that information. And that's happening, and what is then happening is these claims are going away. So the aggressive defense counsel that is using this offensively is now becoming, again, a kind of the professional that everybody goes to because they are actually using this opinion to their advantage. The other thing is that Garlock is now suing 6 of the larger asbestos law firms for fraud to get even more information on what was going on behind the scenes in the tort system while they were extorting money from Garlock, in my opinion. The other thing that has happened with this opinion that is bolstering the legislative efforts out there that are trying to force these trusts to fully go transparent to a certain extent, to still protect some personal identification, but if you are a litigant in the system or you're being sued by an individual, you should get all of the information that individual has with regard to their trust claiming history. And I'd rather be a defendant that has 20 different trust claims from my plaintiff versus a plaintiff that gives me nothing, and I'm able to just simply say, your product is the only thing that made me sick. And the last thing that I will say is, what else is out there? What are some other mass torts out there or class action behavior out there that is actually causing this type of skewing in the economy to where we are funding asbestos plaintiffs and other plaintiffs bars out there and plaintiffs at the expense of disclosure and ethical behavior by lawyers? So thank you very much, and I hope this helps us a little bit for you guys.